Circuit Court at 9 session with the Honorable Judge Joey Loper presiding.
Morning, ladies and gentlemen. Be seated, please, and court come to order. Court has pending a motion for bail that's been set in this case, and Mr. McDuff, you filed the motion, so are you ready to proceed? And is State of Mississippi ready to proceed as well?
Yes, Your Honor.
Hey, Mr. McDuff, is your motion then, so you may proceed.
Thank you, Your Honor, and good morning. I'm Rob McDuff with the Mississippi Center for Justice in Jackson, along with my co-counsel, Henderson Hill of Charlotte, North Carolina,
Morning.
appearing on behalf of Curtis Flowers. This case is unprecedented in the history of the American legal system. Despite 6 trials, the prosecution has been unable to obtain a lawful conviction. 2 of those trials ended with juries who could not agree and resulted in mistrials. The other 4 were reversed, all for prosecutorial misconduct. In the meantime, Curtis Flowers has spent 23 years in prison without a lawful conviction to justify his incarceration. At the time he was arrested at the age of 26, he had no criminal record, and he has no criminal record today. Over his 23 years in prison since he was arrested, he's had an exemplary prison record. Former Deputy Commissioner for the Mississippi Department of Corrections reviewed his file and said, "It is one of the best prison records I have ever seen." As time goes by, more and more evidence surfaces that points to his innocence. And all of this makes this case different from the legions of capital murder cases in which bail is denied. And as a result of these unprecedented facts, bail is required under the law. And there are 2 provisions of law, each of which we believe justifies and requires the grant of bail in this case. The first is Section 99-5-35 of the Mississippi Code. Any person having been twice tried on an indictment charging a capital offense, wherein each trial has resulted in a failure of the jury to agree upon his guilt or innocence, shall be entitled to bail in an amount set by the court. And in Mississippi Constitution, Article 3, Section 29(1), excessive bail shall not be required, and all persons shall, before conviction, be bailable by sufficient sureties, except for capital offenses when the proof is evident and the presumption great. Now, going back to the statute and addressing it first, the presence of additional trials beyond the 2, the 4th and 5th trials, which resulted in mistrials, is not relevant, particularly given that they were nullified because of adjudications that the prosecutor committed misconduct in each of the 4. In other words, they weren't fair trials. Because those trials were adjudged to be infected by prosecutorial misconduct, because they were unfair, in terms of the 2 trials that have not had those adjudications, in the words of the statutes, quote, "Each trial has resulted in a failure of the jury to agree upon his guilt or innocence," end quote, and therefore, quote, Mr. Flowers, quote, "shall be entitled to bail in an amount to be set by the court." Now, with respect to the constitutional provision, the Mississippi Supreme Court has explained that if a reasonable doubt or a well-founded doubt of guilt can be entertained, then proof cannot be said to be evident, nor the presumption great, and bail is required. Now, we believe the evidence points toward innocence. We believe a reasonable doubt has been established and certainly will be established at any 7th trial if there is one. But that's not the standard. The standard is, can a reasonable doubt be entertained? And clearly it can. more so now than ever before in the 23-year history of this case. We have provided 29 exhibits that go to this issue.
I assure you, I've read everything you found.
I know you have, Your Honor. They go to this issue and they go to Curtis Flowers' exemplary prison record. Let's start, if we can, with Odell Hallman. Odell Hallman was the state's star witness. He testified in the last 4 trials that Curtis Flowers admitted to him in jail that he committed these murders. But now that he is in prison, serving life without parole, there are no more favors that can be done for him by the district attorney's office. And now he is finally admitted to the truth in a recording, in an interview with reporters from American Public Media's podcast, In the Dark. One moment, Your Honor.
For him telling me he killed some people, hell no, he ain't never told me that. That was a lie. I don't know nothing about this shit. It was all make-believe. Everything was all make-believe on my part.
And with that, the DA Doug Evans, star witness, had reversed himself on a contraband cell phone from inside Parchman Prison.
All this shit was just a fantasy. All of it was just a fantasy, that's all. A bunch of fantasies, a bunch of lies.
And this admission from Odell Hallman that this was all a bunch of fantasies, a bunch of lies, just confirms the whole implausibility of Curtis Flowers, who has proclaimed his innocence since the beginning of this case, who is the kind of person, as attested to by prison guards, who is quiet, who is cooperative, who is not aggressive, who is not violent. And the notion that Curtis Flowers would be hanging around with the likes of Odell Hallman and confessing to murders of which he has been accused is preposterous. It has always been preposterous, and now Odell Hallman has confirmed it was all a lie. I used them SOBs just like they used me. That's the other thing Odell Hallman said in this recording. There has been a pattern of favors from the district attorney's office for Odell Hallman that began in May of 2001, when Odell Hallman first gave a statement to Doug Evans claiming that Curtis Flowers had confessed to these murders. 8 days later, an armed robbery charge against Odell Hallman was dismissed, and an arrest for possession of crack cocaine with intent to sell never led to an indictment. And this pattern of favors continued until even after the last trial, when in 2015, the district attorney's office agreed to bail for Odell Hallman despite his criminal record a mile long, despite his prison record that's a mile long, in a case where he was charged with aggravated assault on a law enforcement officer with a deadly weapon stemming from an incident where he tried to run over a Montgomery County Sheriff deputy because he had drugs in his car and was trying to get away. The order was signed, the order that was presented by both parties, an agreed order for his bail, was signed by Judge Morgan in August of 2015 8 months later, Odell Hallman killed 3 people. When you sentenced him, you said, "It's hard for the court to understand the hatred in someone's heart and the darkness and evil in someone's soul that would cause you to do this." This really was a deal with the devil that the district attorney's office made, and it is the supreme irony that the district attorney agreed to bail in that case with that man's record, but is here opposing the bail application of Curtis Flowers. The state's second most important witness was Clemmy Fleming, who admitted to these same reporters on tape that she didn't tell the truth when she testified at trial after trial that she saw Curtis Flowers near Tardy Furniture Store on the day of the murders. This recent revelation is on top of the testimony at prior trials of Stacy Wright, Ms. Fleming's cousin, LaTarsha Blissett, Ms. Fleming's friend, who both testified that Clemmy Fleming admitted to them that she didn't see Curtis near Tardy, and it's on top of the top of the testimony of Clemmy Fleming's sister that Clemmy was with her the entire morning on the day of the murders. Ed McChristian was another witness for the prosecution. He admitted to these same reporters on audio tape that he testified that he saw Curtis Flowers on the morning of the murders because the officers, quote, had it down pat for me, end quote. But in truth, he didn't remember what day it was he saw Curtis Flowers on the street. In addition to these matters, evidence has emerged of at least 3 potential suspects who are much more likely to have committed these murders than Curtis Flowers. The district attorney has maintained from the beginning of this case, quote, "There is no evidence that I am aware of that points a finger at anyone else," end quote. In 2016, you asked Mr. Evans whether, quote, "the state possesses any information on any other suspects," end quote, and he said, "No, sir." John Johnson, the state's investigator, had previously testified, "I'm not familiar with another suspect." But reporters from American Public Media determined that they had investigated another individual at length named Willie James Hemphill. He has an extensive criminal history, including daytime robberies, putting a gun to a woman's head in a parking lot, and extreme violence, including the beating of a girlfriend with a lead pipe and pulling out a phone line when her daughter, her 12-year-old daughter, tried to call the police, and then told the 12-year-old daughter that he was going to spread lighter fluid in the house and burn the house up. He wore the type of shoes that purportedly left a bloody footprint at the crime scene, Fila Grant Hill shoes, and was apparently told by investigators that people had seen him near Tardy Furniture on the morning of the murders. Authorities launched an extensive manhunt for him at the time and arrested him so they could question him about the murders. He was kept in jail for 11 days. However, they apparently released him at that point after he gave them what he later called, quote, "an airtight alibi," end quote, that authorities never checked out and that now appears to be completely fictitious, as discovered by those reporters when they interviewed the woman he said he went to a mall in Memphis with that day, as well as another girlfriend of his. And it turns out that the route from Tardy Furniture to Hemphill's home, where he was living at the time on Branch Street, passes by 106 Knox Street, where a .380 pistol was later found by Jeffrey Armstrong, who said he later told police about it, and that was confirmed by an officer who recalls Armstrong's statement and who understood the pistol was turned over to authorities, although no one knows its whereabouts now. Another suspect is LaSamuel Gamble, who was documented on security footage around the same time as the Tardy murders, wearing Fila shoes during a series of commercial robberies and murders with a team in Alabama. That team used a .380 pistol that tended to jam, just like the weapon in the Tardy murders. Because of the similarities in the crimes, the Mississippi Highway Patrol Lieutenant Wayne Miller obtained a photograph of one of these men to place in a photo array in this case. And one of the members of the robbery murder team provided a sworn affidavit to post-conviction counsel stating that two of the other two were in Mississippi around the time of the murders and, quote, saw a few licks, end quote. Still another suspect, Doyle Simpson, owned the gun the prosecution was claimed to use to kill the victims. His apparent proficiency with the gun included target practice in his mother's backyard, which of course played a prominent role in the prior trials. And he created a public spectacle by walking into a restaurant around 11 o'clock that morning, claiming the gun was stolen from his car. But he himself testified that he went to the car around 9:15 of that morning and again around 10:25 and noticed nothing amiss. It was only during his third trip, which was, he said, at, quote, something to 11, end quote, that he noticed signs of a break-in on his glove compartment. But police officers testified when they looked at the car that day, it was clear the glove compartment had been pried open and couldn't be shut. Obviously, he would have noticed it if, in fact, there had been a break-in prior to 9:30, 9:45, 10 o'clock when the murders occurred. But he didn't. And this undermines the prosecution's entire theory that Curtis Flowers stole the gun from that glove compartment. And in fact, Catherine Snowes, also an important prosecution witness, testified that she saw Mr. Flowers leaning on Doyle Simpson's car at 7:30 in the morning, even though she didn't tell the police about it until a month later. But clearly, that's not accurate. She was friends with Doyle Simpson, by the way, but Doyle Simpson didn't see anything wrong with the car until something to 11, which completely undermines her testimony and the prosecution's theory that Curtis Flowers broke into this car and stole the gun and committed the murders. All of these people are much more likely suspects than Curtis Flowers, who at the age of 26 had no criminal record and had nothing in his background to suggest that he would take a pistol and shoot 4 people in broad daylight in a commercial establishment in downtown Winona. And that is confirmed by Curtis's entire record since then in the Mississippi Department of Corrections and in the local jails when he's not been in prison, where everyone recognizes that he is peaceful, that he abides by rules, that he is not violent, that he's very cordial. All of which suggests, as one of the guards said, he is not the kind of person who would do something like this. In addition, prosecution presented evidence that the bloody footprints left at the scene were a size 10.5, which just happened to be Curtis Flowers' size at the time. But we have presented an affidavit that was obtained by post-conviction counsel. It was originally part of the post-conviction petition in this case, from an expert that said The state's expert had no business saying it was a 10.5, and all you can say at best is that it was within a much wider range of shoe sizes. Now, I realize that in some respects, certainly not all, but some, it could be said that the evidence is complicated and maybe it can go in both directions. But I don't see how it can be said that a reasonable doubt cannot even be entertained. The evidence here is stronger for the defense than it has been in 23 years, and there is already been a significant showing that if we have a seventh trial, Curtis Flowers will be found not guilty. I want to go back to the constitutional provision briefly. It says, excessive bail shall not be required, and all persons shall, before conviction, be bailable by sufficient sureties, except for capital offenses, when the proof is evident or presumption great. This special rule for capital cases comes out of the theory and the long-held principle in the law that a person facing the possibility of death as a punishment is more likely to flee than anyone else who doesn't face that potential punishment. And that's why there's this special rule. It doesn't apply to Curtis Flowers. He has always proclaimed his innocence, and at the age of 49, he's not somebody who wants to spend his life on the run. His father is 77. As the affidavits from the prison guards indicate from watching the family visiting him in prison, he has a very close family, a very supportive family. He knows that evidence has come out since the last trial demonstrating his innocence. He doesn't want to go back to prison for jumping bail. He's not a 22-year-old person who is facing an airtight case against him and is desperate and goes on and would go on the run. He is a person with a significant chance of acquittal who wants to stay and abide by the court's rules and see this case to its finish. The affidavits that were submitted in support of Mr. Flowers regarding his exemplary prison record, I just want to talk about them for a minute. As I mentioned, former Deputy Commissioner Emmett Sparkman said it is, quote, one of the best jail and prison records I have ever reviewed, end quote. Curtis Flowers has an exemplary prison and jail record for an individual incarcerated from 1997 to the present, and the records show he has been a, quote, model prisoner, end quote. He said the reports I received were that Mr. Flowers, quote, did not cause any problems for staff and other inmates, end quote. His records indicate that he is, quote, an individual that is respectful of staff and other inmates and strictly abides by the rules and regulations, end quote. He said the records show no evidence Mr. Flowers has been an escape risk and no evidence that Mr. Flowers would be a threat to public safety or a flight risk if released on bail. Lieutenant Nathan Harris, who supervised death row inmates and directly monitored Mr. Flowers for years, said, quote, from observing Curtis and his exemplary conduct at Parchman, I do not believe he would pose a danger or a risk of fleeing, end quote. When Mr. Flowers was sent back to Parchman after his second trial, he requested a red tag so that he would be kept away from two inmates who had problems with him because he wouldn't join their gang. When Mr. Flowers was held in county jails between trials, the story was the same. The captain, Mike Smith, who was in charge of security at the Carroll Montgomery County Correctional Facility, said Mr. Flowers was, quote, a very good prisoner, end quote, quote, was never an aggressive person and never displayed any tendency toward violence, end quote, and caused no trouble. Based on his observations of Mr. Flowers' excellent conduct in jail, he does not believe that Mr. Flowers, quote, would be a danger to anyone or a flight risk if released on bail. end quote. And one particularly important document here is the inmate classification rating that we attached as Exhibit 6. No institutional violence, no prior felonies, no escape history. Current age, 40 to 49. And Emmett Sparkman, in his affidavit, says this score places him in the, quote, minimum custody, end quote, category, except that he cannot be assigned minimum custody because of his death row status. And once you subtract the points from the conviction that was now overturned, Mr. Sparkman said he has the lowest possible rating. It can't get any lower. So by all of the standards that the Mississippi Department of Correction uses, Curtis Flowers is not a flight risk, and he's not a danger to society. And then finally, Van Hopkins, whose company monitors and supervises prisoners all around the Southeast who have been released on bail, including in Mississippi, looked at all of these affidavits. And he said, based on my experience monitoring people accused of crimes, I believe that someone like Mr. Flowers is highly unlikely to violate the conditions of bail and is not a flight risk or a danger to the public. We've already talked about the statute, which we believe requires bail. We've talked about the constitutional standard, which we believe requires bail. But in addition, there is a case that we cited at page 10 of our brief called the Bridewell case from 1879. And it says that even if the constitutional standard is not met by a defendant, courts have discretion to grant bail, particularly in circumstances like protracted delay in bringing a person to trial. This is an exceptional circumstance where a man has spent 23 years in prison despite the prosecution's inability to obtain a lawful conviction. That is another matter that justifies bail. We filed this bail motion, Your Honor, in September. Included 9 of the exhibits. About 3 weeks later, we filed a supplement with all of the exhibits in which we had taken certain internet sites that were in the original brief and converted them to paper. But for various reasons, it has taken until now, nearly 3 months from the original filing, to hear the bail motion. And there are reasons for that. But it just points up that this is a complicated case, and it is going to take a little while to reach a final disposition. And Curtis Flowers should not have to wait in jail for that process to occur. And I would like to suggest to the court that the appropriate amount of bail would be no greater than the bail amount the prosecution agreed to for Odell Hallman, who is a much greater flight risk and a much greater danger than Curtis Flowers. And that amount was $25,000. I have a copy of the order, Your Honor, if I may present.
Well, I will point out that that is not murder cases that.
You're right. But it certainly was a man with a much longer criminal record and a man who was a much greater flight risk, and as he proved 8 months later after Judge Morgan signed that agreed order, a much greater danger to the public. If you do require bail in a larger amount, we do request that you allow a cash deposit bail under Rule 8.1D so that any amounts deposited can be refunded at the conclusion of the case. The only other thing I want to say is that this is a case that obviously engenders strong feelings. I can't imagine, I don't think many of us can't imagine the horror and the pain of losing loved ones in the sort of violent event that occurred here. And I imagine that members of the families of those people who died have believed, and many still believe, that Curtis Flowers is guilty. But the existence of that tragedy does not mean that Curtis Flowers is guilty. And his family, his friends, his growing number of supporters, as more and more evidence comes out, and his lawyers believe just as firmly, just as fervently, that he is innocent. And as time goes by, more and more evidence comes out to support that belief. But in the midst of these diametrically opposed feelings, which are held very strongly, the law is clear. There have been 2 mistrials in the only 2 trials in which prosecutorial misconduct was not adjudged, the only 2 trials in which there was an adjudication, in which there was not an adjudication, that they were unfair. In those 2 trials, each resulted in a mistrial, and the statute requires bail. A reasonable doubt can, at the very least, be entertained, and therefore bail is required under the Constitution. Curtis Flowers has no prior record of criminal conduct and an exemplary prison record. He is not a flight risk, and he is not a danger. So under the law and under the unique circumstances of this evolving situation, Curtis Flowers is entitled to be released on bail pending further proceedings and during the time it takes to reach a final resolution of this long and difficult and tragic case. Thank you, Your Honor.
Ms. Hopper, you may proceed.
William Hopper, Assistant District Attorney for the state. As for the statutory argument, Your Honor, a plain reading of the statute says, any person having twice been tried on an indictment, charging capital offense, wherein each trial resulted in a failure of the jury to agree upon his guilt or innocence, shall be entitled to bail. It doesn't say reversal, it says each trial. In this case, I believe this statute doesn't apply, Your Honor. There have been 6 trials. Only twice has the jury not been able to reach a verdict. The other 4, they did reach a verdict. While they were overturned later on, the statute doesn't mention reversal. It mentions merely each trial. So for that reason, I would say that the statute does not apply in this case. As for the constitutional argument, Your Honor, as we all know, cases are tried in a court of law, not in the media. It is true that these individuals that he mentioned have given statements to this podcast, these people doing the podcast. However, I would show that there is more proof than just these people's statements that Curtis Flowers is guilty of of the murders that he's been charged with. He was seen at Doyle Simpson's car on the morning of the murders. Doyle Simpson's gun was taken from that car, and a bullet that was pulled from the crime scene matched to that gun. There were gunshot residue elements found on Mr. Flowers' hands. There was a shoe print found that was matched to a Fila Grant Hill shoe. An empty shoebox was found in Mr. Flowers' residence that matched the size of the state's expert as 10.5. Those shoes were not found. Apparently, I believe the statement was they were thrown out, which these were very expensive tennis shoes. I can't envision anybody just throwing them out because they didn't fit. There was money found in the headboard of his bed. I think most telling as far as these other, the defense wants to call them suspects, Willie James Hemphill and Doyle Simpson, was those two individuals had no motive to commit murder. The state has put on evidence at the prior trials, which Your Honor has sat through. You've heard the evidence coming from that witness stand on at least 2 of the prior trials. Mr. Flowers had recently been let go from his employment at Tardy Furniture. He had his final check docked because of some broken car batteries that happened a couple weeks before. And then he just quit coming to work. And then when he inquired, he was told that, you don't have a job anymore. It's not just these 3 individuals, Judge. You've heard the evidence. There's other people that saw him at Tardy Furniture that morning. Porky Collins' testimony was that he saw him in front of the store on that morning as he drove by in his car arguing with another individual. Now, as for this Presley and Gamble, these 2 individuals that were tried over in Alabama for, I guess it is capital murder, that was in Birmingham. And I've seen no evidence that either of those individuals ever set foot in Winona. Just because one of them may have been in Mississippi doesn't mean they were in Winona. Mississippi's a big state. And you heard the testimony in the prior trials that from John Johnson and I believe others that Mr. Flowers was the only suspect. And Your Honor.
Well, I've heard that, but yet after the fact, now I'm hearing that somebody else was picked up and held for a number of days that was in fact a suspect. So how does the state reconcile that?
Your Honor, all I can say is that he gave an alibi. Now, I don't know what was done on it, but there's no other evidence to point that he had anything to do with it other than maybe he had a pair of shoes and maybe someone saw him around the store that day, which
Well, that's about the same type of evidence the state has against Mr. Flowers, isn't it? I mean,
well, no, Your Honor. We have Mr. Flowers being seen near the car where the gun was stolen that we know was used right around the time or just before the murders happened. We have Doyle Simpson saying his gun was stolen. We have gunshot residue on Mr. Flowers' hands. And then, as I was mentioning, the empty shoebox and the money and the missing check from Tardy Furniture that was in Curtis Flowers' name that was missing after this horrible murder. Proceed. Okay. Your Honor, it's the state's opinion that requirements of Mississippi Constitution have been met, and that.
So it's the state's argument that no reasonable doubt can be entertained?
It is, Your Honor. That's our position today. And as such, we would ask that bond be denied.
Since it's your motion, you have the right to follow up if you will choose.
I just think it's ironic that the state is using the other 4 trials as a reason to argue that the statute doesn't apply, when they were the ones who created the unfair trial scenarios that led to the reversals by the appellate courts. Those do not count as a matter of law, and they certainly should not count with respect to that particular statute. There was 1 grain of gunshot residue found on Curtis Flowers, and even the prosecution's witnesses testified that that doesn't mean anything. He could have picked it up in a police car, could have picked it up at the police station. There was an empty shoebox for a 10.5. Curtis Flowers' girlfriend testified they belonged to her son. And as I mentioned, expert evidence at the next trial, if there is one, is going to debunk this whole notion that these prints were a 10.5. The money that was found at the house where Curtis Flowers lived with his girlfriend did not match the amount of money that was stolen. The gunshot testing to claim that this particular gun shot this bullet, where the expert testified he was 100% sure it was. We've also submitted affidavits in the post-conviction petition that suggests the expert had no basis for saying that. But even if it was the same gun, it points much more toward Doyle Simpson than it does toward Curtis Flowers. Mr. Hopper said that these alternative suspects had no motive to commit murder. They had the same motive they had in the murders and robberies they conducted, they committed in Alabama, the robberies that Willie James Hemphill committed in North Mississippi and in Memphis in broad daylight. And that was money. Doyle Simpson had worked at Tardy years earlier. Porky Collins said that he saw Mr. Flowers. Before he said that, he identified Doyle Simpson as the person he saw. And even then, he said whether it was Mr. Flowers or Mr. Simpson, he only got a brief glimpse. That's not much evidence. And the state is wrong when it says that these alternative perpetrators, potential perpetrators, were not suspects. Not only did they hold Willie James Hemphill for 11 days, but they got a photograph sent of one of the Alabama perpetrators, because they were investigating him as well. And I guess the final point is, as you alluded to with your question, we don't have to prove he was innocent today. That's not the question, although I think we could if we had a trial. We don't have to establish a reasonable doubt. We just have to establish that a reasonable doubt can be entertained. And under that scenario, the court is required to grant bail. Thank you.
The court will be in recess, and I'll come back with the court's decision. I'm not going to say a time, but as quickly as possible.